truth of the matter is that, number one, Mrs. Kananu was appointed by an elected governor. The problem I have with Sonko, and many people do, is that he never took his job seriously. All the time when he was sending these letters to the assembly, he actually was doing it as a joke. He never thought...
Okay, he's not here to respond to that.
You have asked me a question. I will explain.
I will ask you to carefully.
I will explain, Mwaura. You remember there was a time he proposed Miguna. You know that. He proposed some other names, and in fact at some point he put a Facebook poll, which Harvey couldn't create for the election, to ask people to nominate a deputy, which is his job as a governor.
I'm hoping now, you'll eventually tell us what your interpretation is.
Please give me some leeway, Mwaura. What we know is that once this name was submitted to the IEBC, the returning officer cleared Anne Mwenda essentially for vetting as deputy governor. At that particular position and point in time, the nominator has become functus officio. You cannot wake up one day and say, I withdraw it after the IEBC. Like today I was in Matungu. Our candidate has been cleared by the IEBC. Can I rise today and say that I have withdrawn that candidate? Now, we must also not run away from the fact that, in fact, the only thing that was stopping Anne Kananu from being vetted as a governor was actually an order of the court. So let us not pretend. I agree with Harvey when he says that, in fact, from a legal standpoint, it presupposes that there are two vacancies in the office of the governor and the deputy by the time you are swearing in the president, the speaker to act. But the question then becomes, are we also aware of the reason why they had not vetted the deputy governor? As we speak here today, Harvey, there was no single court order to stop the assembly either from impeaching Sonko, either the Senate from impeaching Sonko, either the assembly from vetting Kananu, either the assembly from actually approving Kananu. So what has happened, Mwaura? We might see things from a different perspective. I have a lot of respect for the Kenyan courts. We know that these matters are before the judges in the courts. Harvey has filed another case that has essentially stopped the swearing in of Kananu as a substantive governor. And I must make it clear it is Harvey's case because the Law Society has no resolution to that effect. So we will see. We will give opportunity for the courts to look at all these matters.
And as a learned mind, do you see Anne Kananu tonight as a governor designate?
Personally, I know that in law, for as long as somebody is a substantive deputy governor and there's a vacancy in the governor, she's the governor designate. That is the law.
Okay.
Yeah.
You understand?
Wahiga, the process of appointment of a deputy governor commences with the governor and terminates with the governor. An acting governor who is in that office, having ascended from the office of a speaker, does not have the power to appoint a deputy governor. And a question should be asked, and this is the question that should have been asked by the judge in the mask. I cannot identify who or she or who he or she was. You must ascertain that there is a signature under seal by the governor after the county assembly has completed the vetting process for you to sign and say you've sworn in this individual as deputy governor. There is a flaw yesterday. Sorry, there's a flaw in this. And yesterday at the SGM, a member rose, Mary Mungai, and said the Law Society must take action against the judicial officers who were involved in this nefarious act. And it cannot be an answer for you to say that there is no court order. Will I say that there is no court order for me to dispossess you of your watch so I can take it? No. It is deemed that you will act within the confine of the law. And I do not want anybody to go blaming a judge like Justice Murima that he didn't make an order to stop the swearing in. The responsibility is upon the county assembly to ensure that they do the right thing. And that is the reason as to why we went to court, because the county assembly, when left to its own, did not do the right thing. Way forward, IBC must continue the preparations towards a by-election. And the people of Kenya must assert their authority. We should not be distracted from the path of democracy that we took when we promulgated this constitution on the 27th of August 2010. There can be no alternative to the law. If we disregard the law, as has been done right now, we will fall into anarchy. It is as simple as that, Wahiga.
Sifuna, what I'm trying to understand
you have disregarded the law. You have disregarded the law at the LSK. Where do you find
Edwin,
the strength?
Move on.
Where do you find
need
the
to learn
strength
the art
to
of moving
people?
on and progressing.
Allow me to speak. Allow me to speak. Where do you get the strength to lecture people about observing the law? A simple statute, only one, and some simple regulations, not more than 100.
You've made your point,
You've been
Sifuna.
unable to follow. Then you can sit here and lecture people about following the law. You have no moral fiber to argue like that.
Sifuna.
The truth of the matter is, Waihiga.
Yes, and let me throw in my question.
Yes.
How can the law apply retroactively? How do you then move back to a point where the Constitution, the supreme law of the land, has already moved to the next step, where a speaker is sworn in? How do you then move in reverse?
Exactly.
The deputy governor takes over. Help us understand how you as a legal mind interpret that.
This is the concession that I made. That in fact there are certain absurdities. I started by conceding.
You see it as an absurdity.
Just a minute. Mwaura, please allow me to be your guest.
Allow me to interrupt, and I need clarification as well. You asked the same for the president, so I think...
Allow me to be the guest.
Go ahead.
Now, I conceded that in fact, even from my own reading, by the time a speaker is being sworn as an acting governor, it presupposes in law that there are two vacancies, both in the office of the governor and in the office of the deputy governor. I have also told you that we cannot run away from the fact that there was a valid nomination of deputy governor and that in fact it was stopped by a court order. When I talk about the absence of court orders, I am referring to the fact that some of these issues had actually been already ventilated before a court of competent jurisdiction. We must allow the absurdities that we cannot resolve at a personal level because of the differences between his understanding of the law and mine, talking about this matter, because he is the petitioner in the case that has been filed in court challenging this matter. So he knows that as a legal principle, we should not essentially be sitting here to discuss the merits. I have just given you my point of view. I am ready to cede my understanding of the law to a higher organ, which is the courts that have the competent jurisdiction to determine this matter. And by the way, Mwaura, nobody is afraid of a by-election in Nairobi. It is a fallacy that has been thrown around in certain circles. You have seen the president here repeat them, and I know that he represents certain factions in the political space in this country. I can tell you for a fact, Mwaura, that nobody is afraid of a by-election in Nairobi. If the courts decide that in fact we are going to have a by-election in Nairobi, we will be there to participate in that election. So nobody should sell the narrative that somehow we are afraid. We are not afraid of anything.